Hello, it's January 16th. My name might be Caleb Reese, and we are in the second week of ICE occupation in Minneapolis. And since I can't focus on anything else, let's talk about ICE's legal powers, namely what they can and cannot do by law. So first off,
you need to stop following.
First and last warning.
It's not illegal.
I know, but it is illegal to impede.
You're gonna get arrested.
We're not impeding.
Yes, you are.
Following us, you are impeding operations. This is the United States federal government.
No, for what? You fall off again, we're going.
I'll work around.
is it legal to record ICE? Last June, a DHS bulletin directed officers to consider, quote, use of cameras, live streaming, and video recording at protests as unlawful civil unrest tactics and threats. That July, DHS Secretary Kristi Noem clarified that violence includes anything that threatens agents and their safety, so it is doxing them, it is videotaping them where they're at. Furthering that idea, DHS Assistant Secretary for Public Affairs, Tricia McLaughlin, later reinforced this characterization of filming agents, telling reporters that, quote, videotaping ICE law enforcement and posting photos and videos of them online is doxing our agents. We will prosecute those who illegally harass ICE agents to the fullest extent of the law. Well, that is an open and shut case. As long as you forget about 1791's First Amendment to the Constitution, drafted by the OG James Madison, future president. The First Amendment protects the right of free speech, freedom of the press, freedom to assemble, and so forth. But I know what you're thinking. Well, video recording didn't exist in 1791. Well, in 2005's Robinson v. Fetterman, the Third Circuit Court held that there is a free speech right to follow and film officers in performance of their public duties. 5 years later, in 2010's Citizen United v. the FEC, the Supreme Court also recognized that, quote, if a law restricts filming itself, one could argue that such a law restricts a medium of expression and thus an integral step in the speech process. 2 years later, the Seventh Circuit Court of Appeals upheld this as well. In fact, every Circuit Court of Appeals to date has sided with this. Recording federal officers in performance of their duties is very much protected under the First Amendment. Full stop. Now, DHS declared video recording unlawful because a protester chased an ICE agent, followed them home, gave their name and address on the video, and made a call to violence against them. That crossed the line. But that doesn't mean now that everyone's prohibited from recording agents. The law does not work that way. Likewise, ICE agents have been claiming it's illegal to follow agents. Well, no. The same court case protecting freedom of speech and every court of appeals affirms that as long as you're not actively interfering with their operations, following and observing law enforcement is perfectly legal. The agents might get scared or anxious, but their personal feelings do not preclude the laws as set forth by the Constitution of the United States. Now, that may be the law. But then again, human rights organizations like the Electronic Frontier Foundation stress that law enforcement officers may illegally retaliate against you in a number of ways, including with arrest, destruction of your device, and bodily harm. All the things we are seeing right now, thankfully, because they're being recorded. Now, it is illegal to obstruct traffic, like they used to justify killing Renee Good. But then again, if you see the video, you'll also see that she wasn't obstructing traffic either. Neither was this gentleman in Stevens Square. Actually, the ICE agents were parked on the wrong side of the road, but I guess they're allowed to make the situation for motorists much more unsafe, right? Is it legal for ICE to make traffic stops? Generally, for American citizens, it is not legal for ICE to make traffic stops, but this does get a little muddy. According to DHS rules, when ICE officers reasonably suspect that a vehicle contains undocumented immigrants, they can briefly stop the vehicle to investigate the circumstances that raised their suspicion. But they need an objective basis for this. They cannot just rely on a hunch. But, and I cannot believe I'm saying this, 2025's Vasquez-Perdomo v. Noem, the Supreme Court determined that immigration stops that rely solely on race, ethnicity, or speaking a different language can constitute a reasonable suspicion. Now, this being said, according to publications like the San Francisco Chronicle, legal scholars such as law professor Bill Hing state that ICE's authority ends once they confirm someone's a U.S. citizen. So if anybody has an ID or a passport on them, this should be the end of it. Keyword should. Now, is the idea that you have to carry your papers around or risk being pulled from your vehicle drawing parallels to the German Gestapo? Do I personally think this is literal racial profiling and wrong? Yes, but my opinions and feelings aren't the law. And according to the Supreme Court, if you're white right now, you have more rights currently, which is wild. For those of us, though, who look legal, ICE can't simply break the glass and pull you out. In fact, according to the New York Times, the first step in arresting an occupant of a vehicle is not to reach in and grab them, unless there are specific circumstances requiring that action. So ICE shouldn't be smashing and grabbing immediately from vehicles if they don't like you. If they do, this is illegal. If they're blocking traffic, which they were for this woman here, and also telling her to get out, then break the glass and force her out, this is both illegal and also a gross use of escalation. But as of January 16th, that's just where we're at when it comes to vehicles. Pivoting now, though, from vehicles to homes, can I smash down your door and abduct you? That is thankfully a hard no. 1791's fourth constitutional amendment restricts unlawful search and seizure of one's property, including their home. 1948's Johnson v. United States explicitly affirmed a warrant was required for Fourth Amendment violations. Justice Robert H. Jackson described warrants as a judicial check on the executive by, quote, a neutral and detached magistrate, rather than the officer engaged in the competitive enterprise of ferreting out crime. He asserted the Fourth Amendment separated America, quote, where officers are under the law, from a police state where they are the law. Jackson, by the way, was the chief prosecutor against Nazi leaders at the Nuremberg trials. This also absolutely applies to rental properties, thanks to 1967's Katz v. the United States, in which the so-called Katz test declared that the Fourth Amendment protects people, not places. The test is twofold. One, did the defendant have a subjective expectation of privacy? And two, is society prepared to expect the expectation as reasonable? This is the same reason why tapping your phone without your knowledge also violates the Fourth Amendment. All law enforcement divisions, from federal to local, require a warrant, and not just any warrant. This is especially important after ICE forcibly entered the home of Garrison Gibson on January 11th with an administrative warrant. Recall Justice Jackson's declarations asserting a neutral and detached magistrate. Administrative warrants being issued by an agency and not a detached magistrate or judge are exclusively for civil and administrative matters and cannot bypass Fourth Amendment rights. The ICE agent who arrested Garrison Gibson were absolutely violating federal law. That's another reason why recording things are so valuable right now. Now, if you're in an apartment, duplex, or other building with a common entry, you should be aware. Right now, only the Sixth Circuit asserts that common areas are protected under the Fourth Amendment if the doors are locked, while the Seventh Circuit argues these protections apply to common areas overall. So can ICE enter your unit without a warrant? No. Can they enter the building, the lobby, your hallway? For the most part, yes. In some locations, no. New York's Constitution, for example, codifies these rights for all properties rather blatantly. Other states, even Minnesota, don't explicitly guarantee these rights, though.
Where's the warrant? You can't go behind there. Where's the warrant?
It's an electronic warrant.
Can ICE enter your place of business? That is a no, with an asterisk. As guaranteed by the Fourth Amendment in 1948's Johnson v. United States, all private areas, that is, areas where customers are not permitted in a business, constitute a socially reasonable subjective expectation of privacy and therefore require a judicial warrant to access. ICE cannot enter these areas without the consent of the shop owner, nor can they inquire about any persons or documents in these private areas. These permissions, though, don't necessarily apply to public spaces, such as dining areas, the service counter, or entryways. Now, that being said, Title II of the Civil Rights Act of 1964 prohibits discrimination by places of public accommodation on the basis of race, sex, color, religion, and national origin, but it does not based on occupation. Refusal based on occupation is considered non-discriminatory, especially when cited due to potentially disruptive behavior, safety concerns, or dress codes. So in this case, businesses may refuse ICE agents and especially entry, provided there's written notice on the business or an employee present to refuse said entry. The experience at Rectangle Pizza on the corner of Lyndale and Lake Street, perfectly justified, as is the harassment of the ICE officers outside the building. 1949's Terminello v. Chicago asserts that freedom of speech, although not absolute, is protected against censorship or punishment unless it's shown likely to produce a clear and present danger. And in 1969's Brandenburg v. Ohio, it was backed up by declaring the government cannot punish inflammatory speech unless that speech is directed to inciting or producing imminent lawless action. That is to say, threatening. How'd you like it if I came over there and beat you up? That's hypothetical. That's protected. Saying, I'm coming to your home and beating you tonight. That's prohibited. Threaten to overthrow the government? That's protected. Have a formulated plan to overthrow the government? Now that's illegal. 2011 Snyder v. Phillips upheld that deeply offensive speech is still protected because allowing punishment based on emotional harm would be considered unworkable and dangerous. 2012's U.S. v. Alvarez reinforces there being no exception for false statements either, given, quote, the common understanding that some false statements are inevitable if there is to be an open and vigorous expression of views in a public and private conversation. Most recently, 2024's NRA v. Vullo asserts the First Amendment prohibits government officials from wielding their power selectively to punish or suppress speech, including through private intermediaries. There are so many more cases that it would take forever to go through all of them. The important thing is, as long as it doesn't constitute an imminent threat, we can say it, and they have to suck it up. That's America. If they punish us, that is, say it with me, against the laws of America. And as for punishment, can ICE provoke or escalate a situation? Well, according to Stephen Miller, ICE has, quote, federal immunity in the conduct of their duties, and no one, no city official, state official, illegal alien, or leftist agitator, or domestic insurrectionist can prevent them from fulfilling their legal obligations and duties. That is a powerful statement. I mean, it's not correct, but it really sounds strong. You don't even need to look at the court cases for this. The official DHS use of force policy updated in 2023, page 3, article 3, section C, use of safe tactics, explicitly states DHS officers should seek to employ tactics and techniques that effectively bring an incident under control while promoting the safety of officers and the public that minimizes the risk of unintended injury or serious property damage. DHS should also avoid intentionally and unreasonably placing themselves in positions in which they have no alternative to using deadly force, like stepping in front of a car. Further down, Section H asserts that the use of excessive force is unlawful and will not be tolerated. Those who engage in such misconduct and those who fail to report such misconduct will be subject to applicable administrative and criminal penalties. That same article goes on to say that failure to intervene in and report such violations is itself misconduct that may result in disciplinary action, with potential consequences including removal from federal service, civil liability, and/or criminal prosecution. Also, according to Now This News and Pod Save America, DHS released an internal memo to ICE agents here in Minneapolis this week reminding them that it is not a crime for protesters and citizens to do a variety of things, including swearing at them, calling them names, belittling their character, flipping off ICE agents, yelling at ICE agents, filming ICE agents, refusal to cooperate with ICE agents' demands, and disobeying commands without fighting back. According to DHS, this is their policy, straight from the horse's mouth. Now let's talk about Renee Good. Page 6, Article 5, Section A states that except in the limited circumstances, officers are prohibited from discharging firearms solely as a warning or signal or to disable moving vehicles, vessels, aircraft, or other conveyances. The exceptions are only for maritime aviation and Secret Service, by the way. Just a bit down in Article 4, use of deadly force. Officers may use deadly force only when necessary. That is, when there's a reasonable belief that the subject of such force poses an imminent threat of death or serious bodily injury to the officer or another person. So how would executing the driver of a moving vehicle in any circumstance fix the threat of being run over? I'd argue, seriously, that killing the driver places all agents and community in extreme danger because now you have an uncontrolled speeding vehicle. There's no reasonable situation in which killing a driver prevents Ross from being run over, nor would killing the driver protect the public or other agents. And I don't care what Kristi Noem or Stephen Miller says, this basically comes from DHS proper. So in review, it is perfectly legal to record and follow ICE as long as you are not directly interfering with their operations. Following them doesn't count, no matter how much you'd like it to. ICE cannot make traffic stops, but they have broad ability to detain people they suspect of being immigrants, though excessive force by breaking glass and pulling citizens out of cars is definitely not allowed, especially when throwing conflicting orders. ICE is not allowed to smash down people's doors and especially abduct anyone unless they have a judicial warrant. This also means they cannot go door to door doing that either. They cannot enter a place of business without permission and not the private areas without a warrant, and may be refused entry or service without protection. We can say whatever we want to them as long as it's not a direct threat, and they have to suck it up because they're public workers. They're not permitted to use excessive force or escalate a situation or use lethal force unless their life is in danger and lethal force can realistically do something about it. And if they do any of these things, which they are doing, they do not have immunity and are subject to prosecution. Now, can we do anything about this now? No. The sad reality is that laws don't stop bad behavior. They only offer consequences for that behavior at a later time. This is a hard road ahead for us all. But that's why in order to collect as much evidence as possible, we need to keep recording as much as we can, including, and especially... You know what? This is a heavy subject, so let's just... On a more timely note, this week federal judge Catherine M. Menendez declined to halt ICE operations in the area, claiming there isn't enough time to assess the merits of the request. It doesn't mean that she won't at a later time. Now, that being said, Menendez set a deadline of Jan 19th for the government to respond and Jan 22nd for the state to reply. Even if nothing much comes of it, next week's definitely going to be newsworthy. And to update this, you might notice it's nighttime now. Well, that's because as I was finishing editing this, Menendez has barred ICE agents from retaliating against protesters in Minnesota. This injunction was just filed a few hours ago and includes retaliating against protesters, arresting or detaining people absent probable cause, using pepper spray and other munitions to those peacefully protesting, and stopping or detaining drivers and passengers when there's no reasonable suspicion. This also includes drivers who safely follow federal agents. DHS is ordered to notify all federal agents within 72 hours of this recent event. Basically, everything I've just said in this video, she's demanded they stop. Now we're getting somewhere. Just remember, do not actually impede their operations or they'll use force against you. Do not throw actionable threats, do not incite violence, do not attack, you will not win, and it will only escalate things further. As disgusting as it can be in this moment, small change steers the ship, clearly. The cases we build now build upon each other. And most importantly, please be safe out there.